Hi there, I'm Savannah Mexto with Manor Law Group, welcoming you to another webinar Wednesday with esteemed estate planning and elder law attorney, Bob Manor. On this week's webinar, Attorney Bob Manor will help you and we'll discuss how seemingly innocent transfers and favors you do for an aging family member could accidentally cause complications and maybe even penalties for Medicaid eligibility. But before I pass the mic to Bob, I'd like to cover just a few housekeeping details. First, note that even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation, please contact us after the webinar. Now, if you have a general question during today's presentation, we encourage you to use our question box. We will save time to review questions during the webinar, but if for some reason we don't get to your question, we will contact you after the presentation. Also note that today's presentation will be recorded and the replay will be sent tomorrow so that you can share it with your family, your friends, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Manor Law Group have to say? We are a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Manor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He is currently chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. And my favorite reason, Manor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome Attorney Bob Manor.
Hi, folks. We're going to get right into it today. This is a very specific topic, obviously, and so I'm going to talk to you about this court case, which kind of covers a lot of the examples of what I would call an accidental gift or an accidental penalty in a very typical situation. So first of all, let me say I disagree with the decision that the judges made in this case, but it's a good example of what the state is currently calling a penalty or a gift that would cause a penalty for Medicaid purposes. So first of all, why do we care about penalties? What does that mean? Well, it basically means you're going to be denied Medicaid for some period of time as a result of that. And it's a time penalty, meaning that you will, once you're otherwise eligible, everything else is otherwise eligible, then they will say, even though you're eligible for Medicaid, we're still going to deny you Medicaid for this period of time as a result of this penalty or this, what sometimes we call a gifting penalty. Sometimes it's not even something that you and I would consider as a gift. So I'm going to use the example of Betty Jensen as the example. And if I recall correctly, I think I've seen a picture of Betty Jensen at one point, and she looks a little bit like the graphic that we had on the cover for the presentation today. So I thought that was kind of ironic. But so a couple things about Betty Jensen. So Betty Jensen was a pretty typical situation that we're often working with families in a situation like this. She was elderly and she had some memory loss. She had dementia, and her and her family were really trying to do their best to give her the best quality of life. And they had a real desire for her to stay in her house as long as possible. Even with the dementia, they were going to help her stay in her house as long as possible. So their grandson would often come around and help out and drive and do errands for her and drive all around and things like that. The grandson was Jason, who is also listed in this court case, and as the personal representative of the estate of Betty Jensen. And so Jason would come by, help her out, and then would eventually got reimbursed. And this was over a period of about 10 months. So from May of 2011 through March of 2012, so about 10 months. And over that period of time, Jason spent his own money to drive her around and do certain errands and pick up certain things, and so eventually Betty reimbursed him for the things that he had done for her, as far as for gas money and those types of things. And it was to the tune of $1,400. So we're not talking about tens of thousands of dollars, right? We're talking about $1,400 that she paid to her grandson to reimburse him for things that he had spent money on. They also were able to hire a neighbor, Teresa Alexander, and so Teresa Alexander was a neighbor. She was had been helping out some elderly folks, and they said, well, we'd really like you to help out our grandmother, Betty Jensen, and come by and help her in the house, and we'll pay you an hourly rate. And over a period of 10 months, they paid her $19,000. Now, if you look at it, you say, well, $19,000, that's a decent amount of money, but over 10 months for care? Now, a lot of people would say, well, that's still a lot of money. Yeah, absolutely. There's no question that that's a lot of money, but it's not anywhere near the going rate. If they had hired, at the going rate, if they had paid fair market value for Teresa Alexander's services, it would have been 3 or 4 times that, probably, for the 10 months that she provided these care services for Betty. And what happened is, as you can see by these numbers, Betty didn't have a lot of money. So sometimes when we talk about Medicaid, you'll hear politicians or somebody kind of grumble about, oh, people are getting on Medicaid and they've got all kinds of money hidden away. Betty didn't have a lot of money, and she was using her money to be able to stay in her house. She wanted to reimburse her grandson for the gas money that from driving her all around and doing all the errands for her. And she wanted to pay the neighbor to provide her help in her house, which she absolutely needed. And there was no question in this case that Teresa Alexander had performed these services. There was not a doubt that she performed these services. And after the fact, there was not a doubt that this was necessary. In other words, they could have gotten doctor's testimony or things like that said, yes, that Betty Jensen needed the assistance. It says right in the court case that she had dementia. So that's a given. It's not even a question. So what happened? Well, eventually she had to go into a nursing home because 2 things. Number 1, she needed that level of care. And number 2, she ran out of money, okay? And sometimes that's what it is. And so ideally, you don't run out of money before you go into the nursing home, but that's what happened to Betty Jensen. She did run out of money. She went to the nursing home. She applied for Medicaid, and the Medicaid department denied her or caused her a penalty, not just a denial, but a penalty for the money that she paid to Teresa Alexander, for the $19,000 over 10 months, and for the $1,400 she had paid in reimbursement to her grandson. And so the family was able to find a local lawyer. This was up in Muskegon, where this case was originally at. And they were able to find her a local lawyer. And the lawyer said, wow, boy, this doesn't seem right. And so she appealed it. And she appealed it to the first level appeal, and then she appealed it to a circuit court, which is the Court of Appeals, the first level Court of Appeals for an administrative matter like this. Well, the circuit court judge is sitting as an appellate court judge, said a couple of things. They decided that the money that they paid to Teresa Alexander was not a gift and should not be penalized, right? Teresa Alexander was the caregiver. But the local judge, the circuit court judge, did say, well, because the money wasn't reimbursed in exactly the right process and exactly the right time frame and things like that to her grandson Jason, the judge upheld the penalty for the $1,400 that had been paid to the grandson Jason. And so this tells you a couple of different things, because those are very common things where the family is doing things for mom or dad or spouse or whatever, it's usually mom or dad, and then getting reimbursed later. And we're going to talk about that in a little bit more detail about how you can do that and the better way to do it But in this particular case, even at the Court of Appeal or at the circuit court level, they said, no, that is going to cause a penalty because you were paying money to your grandson, even though the argument was this was just for reimbursement of gas and things like that. So here's where it gets bad. The Attorney General at the time, it's a different Attorney General now in Michigan, but the Michigan Attorney General at the time decided to appeal this case, which in my mind is really surprising because this is over $19,000 paid to a caregiver that is being paid not even fair market value for her services, and not a lot of money in the overall grand scheme of things. And I also feel that the Attorney General is misapplying the law, misapplying the regulations in the position that they took with the Court of Appeals. But this did go to the Court of Appeals, a 3-panel judge at the Court of Appeals of Michigan, and they actually upheld the penalty for both the money that they paid to Teresa Alexander and the money that they paid to Jason, the grandson. So think about this. Let's put this in context. Now, I've told this whole story, but let's actually really kind of dive down to the context of this. So Betty was just trying to stay off of Medicaid. She was doing what we all would think would be the right thing to do and what people in the Medicaid office would think would be the right thing to do, which is to stay home, to stay off Medicaid, not apply for Medicaid until she absolutely had to, and not even paying exorbitant amount of money, just paying, less than what she would normally pay an agency or anything like that for the care. So doing everything that you would think a responsible citizen and a responsible family would do, which is to try to give Betty the best quality of life, do what seems is common sense, and they're trying to penalize us for this. And so in fact, they did, and the case was upheld, and it never got appealed to the Michigan Supreme Court. Now, you're going to notice something, or I want you to notice something about this, that, oops, this is, I was going to try to highlight something here, but this is an unpublished case. Why do I mention that? Well, what does unpublished mean to lawyers? Unpublished means it does not hold precedential value. What does precedential value mean? It means that it should not be relied on for others, for other judges. Now, that's not entirely true. I've had lots of cases where where I've done it and the other side has done it, where we've cited to judges unpublished cases. Now, we know that they don't hold precedent, but the reason why it's important and that why we look at that is that they're still, have, here we go. I was looking for the highlighter. There we go. So they still have value from the standpoint of persuasion. And so we will often cite unpublished cases for persuasion. But it gets worse. If that wasn't all bad enough so far, it gets worse, because after this case came down, they went and changed the law to comply with the case. So they went back and changed the regulation, what's called the Bridges Eligibility Manual. So that's the manual that we use to make decisions that governs Medicaid. And so they changed the manual, the Medicaid manual, to comply with this case. I would argue, and many would argue, that the Court of Appeals actually misinterpreted the manual as it existed at the time that this case was heard, because what they were basically saying in this case was that in order to pay Teresa Alexander, we would have had to have a notarized contract with her, which was signed off on by Betty's doctor. So we have to have somebody on behalf of Betty sign it and have their signature notarized, have Teresa sign it and have her signature notarized, and then have a doctor sign it. How many people do that? How many people go and have, when they have a neighbor or somebody come by, or they hire a caregiver or even a caregiving agency, and they say, oh, well, let's go by the bank and notarize this, agreement. Most people don't even have an agreement, not even a written agreement. And who would think of going then to take it to the doctor and have the doctor sign off on that? That's just not something that's common sense or that anybody would think of. My point I'm saying that this is considered, what they're basically saying was this was gifted money to Teresa. Well, it's clearly not gifted. In any sense of the word, it's clearly not gifted in any sense of the word that we would think of in the English language. And so, but that is the law right now. If we pay a caregiver and we don't have a notarized contract where it's signed by somebody on behalf of the person that needs to be cared for, whether it was Betty or somebody that has legal authority for Betty, and the caregiver themselves both have to sign it, and both signatures have to be notarized, and it has to be signed by a doctor, and it has to be detailed as far as what's going to be included and what's the contract and what's the value and what specific things they're doing. There's all of these legal technicalities in here. They're saying that that's going to be counted as a gift. That's the biggest, what I would call, accidental gift. That's not really even a gift, but for Medicaid purposes, it is. All right, going forward, how do we protect ourselves? Well, a couple things. The first thing is right now we should just comply. As awful as it is that they require this, if we're paying a caregiver to provide care in our home or care in an independent living or something like that, we should just comply with this rule. We draft these care contracts all the time. If I had it where I never had to draft a care contract again and I didn't get paid for care contracts again, I would strongly prefer that, because I'm just very opposed to this rule and this law. It makes no sense to me. It's bad public policy. I think it's bureaucracy run amok. Bureaucracy run amok, meaning that we have, these bureaucrats that just they're just putting up barriers to Medicaid just for the sake of putting up barriers and hurting real people like Betty Jensen. Because it's not like Betty had $1 million and she was paying all these money out to people. She reimbursed over a 10-month period her grandson $1,400 for gas, for groceries, for prescriptions, whatever it is that he was paying out of his pocket. Okay, she paid for a neighbor to come by and help her out in her house. Nobody would think of doing a notarized contract and having it signed by the doctor in order to do that. But because of the way that the court interpreted it, and now what's written into the Bridges Eligibility Manual, meaning this is the law as it exists now. So what do we do right now? We should just comply. So if you have that, call us up. We'll help you draft that contract. We'll help you get it notarized. We'll get it. It's easy for the doctor to sign off on it. What else can we do? Change the law. And I work with a number of attorneys that are eager to change this law. So I have a friend of mine, she took a case just for the purpose. It was a great case. The facts were great. She did it just for the purpose of trying to get back into court and try to overturn this, to have a judge overturn this and say, this is absurd. You can't, this is untenable. She took it to the point where it was about ready to go to the circuit court, and the department decided to withdraw. And they said, okay, we're not going to charge the penalty. So that sounds good. Okay, she kind of won. Well, she was all set up to do the appeal, but they basically just said, never mind, we're not going to apply the penalty in this case. Why did they do that? Because they probably thought they were going to lose in circuit court. They probably thought they were going to lose in the Court of Appeals, because it was a great case and a great lawyer that was taking the case. And so we're trying to find a great case where we can, overturn it in the courts. Even better is overturn it through legislative action or administrative action. In other words, have them change the rule. Because I don't know of a single person who can justify this and say, in the court decision, it kind of talks about, they kind of reluctantly said, well, we think this is what the law is, and we don't necessarily like it, but we think this is what the law is. But they're basically justifying it to the extent that says, well, we make sure that's not a sham transaction or things like that. Well, okay. There's lots of ways to show that it's not a sham transaction, that there was actually care. If this had been $200,000 transferred to a child that claimed that they were doing care, then okay, we've got a different story. That's not the facts here. So you can't just throw the baby out with the bathwater kind of a thing. You can't just throw it out and say, well, because there's the possibility that there could be a sham transaction somewhere, we're going to penalize everybody because there might be somebody that could be bad. Well, we can prove that through other things. There's evidence of other things. So the bottom line is we're trying to get this overturned through a number of ways, whether it be through the court or administrative process or the legislature, frankly. So, and we have a lobbyist through the State Bar Association that's working on these types of things. I spent this much time on this case because it kind of shows the things that we have to be aware of when we're worried about Medicaid. And so anytime, I always say, look, you can spend, if this was Betty, you can spend Betty's money on Betty or on anything that Betty owns. So if Betty's house needs a new roof, we can pay for a new roof. What we can't necessarily do is pay Son, who is a general contractor, to repair the roof, especially if we don't pay Son simultaneously. We might be able to do that, but we have to make it look like an arm's length transaction where we have a contract, we're paying simultaneous with the work being done. So if Son fixed Mom's roof and then right before she goes into the nursing home, she says, well, I never paid you to fix the roof, and it's 6 months later and she pays $6,000 to fix the roof. No, they're probably gonna throw that out because they say, well, you didn't pay at the time that the work was done. So that looks like a gift to us. But the bottom line is there's so many of these things. And then the other thing is, let's talk about Jason, the grandson. So he legitimately was spending his own money on his grandmother, and she was just trying to reimburse him for that. So how do we do that? Well, the first answer is this. They're going to scrutinize checks or money to the kids or grandkids or relatives. Okay, they're going to scrutinize those much higher than if we had just used Betty's debit card to get gas to be able to do those errands, or used Betty's debit card to purchase the prescription at the pharmacy. But what a lot of families do, and we see this all the time, a lot of families say, well, I just, it's convenient for me, I just pay for it. Maybe Betty didn't even have a debit card or a credit card or something like that. So kids pay for it. And then once a month or every few months, they say, well, here's all the receipts and pay me back for that. The department right now is saying, no, you paid for it. If they're going to pay you back several months later, that's going to be considered a gift and they're going to penalize you for that. So there are two ways I say that is, first of all, if you have to get reimbursed from somebody that might be needing Medicaid and anywhere in the near future, number one, you want to keep the receipts for what it is you're being reimbursed for, and you want to get reimbursed simultaneously or quickly within the time period, shortly after you spent the money. If you spend the money 1 month and 6 months later you reimburse yourself, they're probably not going to accept that. So you want to only reimburse yourself or you want to set it up so that you're reimbursing yourself quickly, or not reimbursing yourself. Mom is reimbursing, dad's reimbursing you quickly, okay? Secondly, we want to keep the receipts. Better answer is, let's not reimburse. Let's just make sure there's a way for you to buy mom or dad's stuff with mom or dad's money directly so that they're not having to write you a check or give you cash or whatever. That's the other thing, is that if there's a lot of cash transactions, you want to be very careful about that. I know lots of older folks, they love to work with cash. They don't like to have a debit card or credit card or write checks or things like that. So they like to work with cash. I have lots of clients that up until a certain point, they were paying most of their bills with cash. They would go buy consumers and pay cash for their electricity and all the rest of that. And I always say, well, okay, at this point, we're going to have to stop that. And they said, but this is what I've been doing for 20 years. I understand. But now there's some dementia. Now it's the kids are helping with the paying the bills and things like that. Now we need to switch over to something that's more we're more trackable, because if there's just a bunch of cash, we're going to have to explain what that cash was spent on. And I always say this is kind of tongue in cheek, but it's also kind of true that when it comes to Medicaid, you're guilty until you can prove yourself innocent. And what I mean by that is if they flag a transaction, if they say, well, you took out $1,600 in cash, prove to me what that money was spent on, we have to prove it to them. I'll have people will say sometimes, well, how do they know that she just didn't lose it, or that she went to the casino or whatever? Well, they don't have to. It's that you have to prove it. So if in fact she went to the casino and lost it at the casino, that's gonna be hard to prove, right? Maybe you could get video, I don't know, but the bottom line is you have to prove it. And if you can't prove it, it's not their burden, it's your burden. It's the family's burden to prove how the money was spent. And if it was lost, or, again, Betty's allowed to go to the casino. The problem is, how do we prove that's what happened? How do we prove it? somebody that just because they might need Medicaid in the future, that doesn't mean they can't be frivolous with their money. They can't give it away, but they could gamble, they could buy stuff they don't need, they can do whatever. But as long as they're not giving it away, then that should be okay. But how do you prove that? Because if they flag a transaction, they're going to say, well, how you got to prove where this money was spent. And if you could prove that money was lost at a slot machine at the casino or something like that, then they will accept that. That's actually not oddly enough, that's not a penalty. But how are you going to prove it? So you'd likely get penalized on it, just like with Jason, the grandson here. They say, well, two things. Number one is he probably didn't have receipts for everything, and secondly, he was probably being reimbursed several months after he actually spent the money, and so they ended up penalizing him for the $1,400. Okay. Having said all of this, what's the answer? Because this just sounds, we're the needle in a haystack kind of a thing. How can you ever get Medicaid? And the answer is, this is why we exist. This is why we exist. And I'm saying that in all reality is there are not that many attorneys that know the Medicaid process and can make sure we advocate and get pushed through the system, but that's what we do. And that's why we're needed, is because the Medicaid system can be very precise and very problematic at times. And so what we do is we make sure that we've looked at all the pieces and have an explanation for everything, or come up with strategies or workarounds for anything that already happened. If when I have clients that come in, they say, well, let's say you saw this webinar, or you come in and you talk to me and I ask you about these things, you say, well, we did that stuff. We did pay somebody without having a notarized contract and a doctor's signature. We did reimburse grandson. What do we do now? We'll find a workaround. I mean, we're going to have to acknowledge those things, and when we file the Medicaid application, but we'll find a workaround. And usually there's going to be some kind of workarounds. There's going to be some way we're going to document it. One of the things that my friend did before they took the case to the department actually ended up just saying, no, there's no penalty. She took it to court and had a judge authorize those transactions after the fact. And it's not necessarily what we do, but we're going to find some strategy or solution to say, okay, well, we have this issue, but we need Medicaid, and so we're going to figure out a way of getting Medicaid even though we have these issues. So what I always tell clients is, you can't worry too much about yesterday. So if you didn't follow these rules and you made some mistakes and you paid people without having a notarized contract, and you reimbursed the grandson, and you paid for your son for the roof that he fixed 3 years ago, you've already done those things. We're going to have to work around those, but let's not keep doing those things. So what I'm saying is, we can't worry about yesterday. We can only worry about tomorrow, right? And so going forward, let's try not to do those things. Let's not pay a caregiver without having a care contract. Let's not reimburse unless we're reimbursing, simultaneously or within a short period of time after the money was spent. Let's make sure we're keeping those receipts, or let's just pay for it directly out of mom or dad's account so that we don't have to reimburse. So that's pretty much it. Those are mostly the accidental penalties is associated with caregiving costs and associated with reimbursing the family for things that were legitimate reimbursements, but we've got to follow the rules when we file for Medicaid. All right, so Savannah, let me know if there's any questions, and if so, we will try to answer those. Otherwise, and I gotta get, here we go. Otherwise, Savannah's gonna come on and talk to you about how to get more information from us.
Thanks, Bob. It looks like we do have a question that just popped in. So let's go ahead and see here.
I don't see the question. You'll have to read it to me.
It looks like someone just has a hand raised. Yep. So if you do have a question, I
might be able to unmute you. Whose hand? Okay, so let's see if I can unmute you and you can. I don't know if I can unmute you here. Here we go. We'll give it a shot. Otherwise, you could type your question in. If neither of those things work, then we can contact you after the workshop and answer your question. And Savannah's going to give you instructions about how to do that in a second here. So if you're able to unmute yourself, then you can ask the question live. Otherwise, otherwise you can type it in. Otherwise, we will make sure to reach out to you after the presentation.
Just did. You are unmuted.
Okay, there you go.
No.
I can hear you now.
Our question is, what was the penalty assessed to Betty for that $20,400?
Yeah, so I'd have to do the math because it would be based on they had a penalty divisor, or they have a penalty divisor. This year, the penalty divisor is about, I should have it posted on my wall, $9,600. And what I mean by that is for every $9,600 that they consider a gift or a penalty, they will deny you 1 month of Medicaid, meaning you have to private pay, or actually you won't have the money to private pay. So you have to figure out a way of getting that care paid with it, whether it's by family or the kids or whatever. But we're going to have 1 month that we're not covered under Medicaid for every $9,600. Back in 2012, that was probably in the $6,000 range. So my suspicion is it was about a 3-month penalty. So what that means when the penalty is applied, that means they're not going to start the penalty until she's run out of other money. So she had to be in the nursing home, run out of money, no way to pay for that 3 months, and then they're going to say, okay, we're not going to give you Medicaid for this 3 months. That's how those penalties work. So it's a really bad situation.
Is that penalty Michigan only, or does it apply to other states in the U.S.?
Yeah, it's a great question. Every state is going to have some kind of penalty like that. California calculates theirs a little bit different. They're the last state in the country that, as far as I know, that is still applying the old law instead of the law that took effect in 2006. But every state's going to have a different divisor number. So I told you in Michigan, it's currently for 2021, 9,600 and some change. I think for Tennessee, last I heard, it was only like 5,000 or something like that, which is bad in some cases because we use the divisor actually as to protect assets too. But the bottom line is every state gets to decide what the divisor is for themselves. Michigan currently has that number, but every state's going to have a different divisor. And then California does a little bit of a different calculation, but they're still going to have some kind of a penalty like that. And remember, there's going to be a workaround too. So here's the issue with the workaround. I need you to come in before you run out of money, both because you got to pay me and because the strategy is we're going to have to use the money you have left to work around that penalty. Okay, so I can come up with a workaround. If Betty had come to see me before she ran out of money, we would have been able to come up with a solution so that she didn't have this, problem, this disaster. But if you come to see me after all the money's gone, there's not a whole lot I can do. We might be able to get a judge to overturn it, or that might be one of those test cases, but which we actually have done a few of those where we've taken pro bono cases where there was no money to pay us, but we had a point to prove. We wanted a test case. We have one right now that we're doing that's associated with the husband and wife income, and if one spouse is in the nursing home, how much of the nursing home spouse's income can be applied to the community spouse or the healthy spouse. So that's a pro bono case that we're currently taking, just because we want to prove this point and make sure we create better law. But the idea is to solve the problem is you come in before you run out of money, and then we come up with a plan to deal with whatever penalty might have been incurred by previous actions. All right, so thank you for those questions, great questions. And Savannah, if you want to take over and give some instructions about how to get additional questions answered.
Yes, thanks, Bob, and thanks for everyone for joining us today. As Bob mentioned, we do have some easy ways for you to contact our team. If you're joining us today, you can look in the chat, and I've actually already put in our phone number, which is 1-800-990-6030. Again, that's 1-800-990-6030. You can give us a call if you're not in a position where you can call right now, but you'd like to speak with our team. Also in the chat, I've put a link to a calendar. When you click that link, you'll be able to choose a day and a time when a member of our team can give you a call. So if now's not a good time, but you know you want to speak with us, and if you're like me, if you leave, you'll forget about it until it's in your face again. Just go ahead and schedule a time and we'll call you. There's no risk or obligation to schedule an appointment. There's no cost for this call. It just gives you a chance to ask more specific questions about your situation. We'll ask you questions as well. We get to know each other and decide, are we the best firm to work with you? Or, maybe there's someone else. So we definitely want to just make that first call. So again, 1-800-990-6030, or you can go ahead and click the link. I'll be sending an email out in the next 10 minutes that will also have our phone number and link. You can also reply to that email. And then tomorrow, expect to see the replay sent to your email as well. Thank you so much again for joining us, and we will see you again soon.